see that on your screen?
I can.
Okay. And so we're still in State's Exhibit 5. Do you recognize the type of document that we're looking at
Oh,
here?
yes.
What is it?
This is one of the forms for what's now called a financial disclosure form that have existed over the years. I believe that's the form that was in place a couple of years ago.
Is this a standard form used in family court here in town?
It is. This particular one is from the Self-Help Center. You can tell because of the blank lines that are provided for people to be able to either write or type information in.
You mean these lines?
At the upper left-hand corner, where you would normally, if it was say an attorney's form, you would see the attorney's identifying information, because most of us have it computerized and it pre-prints that way. This is a self-help form for proper person litigants to be able to fill out.
And what is the purpose of this form in family court proceedings?
Well, it's required to be filed with several kinds of cases and issues. For instance, you have to file a financial disclosure form in any contested motion involving money in any way in family court, either support, property, attorney's fees, whatever the financial issue is that's an issue. If you don't, you basically conceded error in your filing. So you're required to file one of these if money is at stake in any way.
Okay. And is this relevant to family court proceedings in general?
Oh yes, I mean it's usually the go-to thing that most family court judges look at first.
When making what kind of determinations?
As I said, property division, spousal support, child support, temporary orders for exclusive possession or of a house, or who would pay what bills. This is used as the financial template to establish what the parties are doing. This particular form is marked the general financial disclosure form. There's an alternate version which is a detailed financial disclosure form for people that say own their own businesses or have certain other financial setups.
For people who have a more complicated financial situation?
Yeah, the other form is, this is, as I said, it's evolved over the years. And this particular, at this point in evolution, it's split into two different forms, a general form and a detailed form.
And if this form is filed as an exhibit to be used at an evidentiary hearing regarding child custody, would a judge consider it to be important in family court?
Well, for custody, possibly, if money issues are involved, but for support, certainly.
And did you have any involvement in the creation of this form or one of its previous forms?
Yeah, the original domestic relations referee was a now deceased gentleman by the name of Terrence Marin. And Terry and I designed the original of what was then called an affidavit of financial condition. It has evolved over the years in multiple iterations to now be a financial disclosure form.
And is this form designed to be, and you testified before that 60 or 70% of cases in family court have a pro per litigant. Is this form designed to be filled out by attorneys or by lay people?
Both. I mean, we have gone to great lengths over many years to make it as understandable as possible. I was not on the committee that designed this version of this form. As I said, it's gone through multiple iterations over the years, but it's a never-ending process to try to make it as user-friendly and useful for the court as possible.
And I'm going to turn to page 7 of this general financial disclosure form, which is in State's Exhibit 1. Do you recognize the page we're looking at here?
Sure, that should be the signature page.
Okay, and I'll move it.
Yeah.
There, okay. And what is this telling us?
Well, it's. I don't know.
Objection, the document speaks for itself. It's already there.
And I'm sorry, would you mind repeating the question?
Sure. What is this document telling us?
This is the certification that an individual has filled out the information disclosed on prior pages and on this page accurately, completely, to the best of their knowledge and their kind of perjury.
Is this a standard part of the general financial disclosure form?
Yes, it's been there since the very first one that we developed in one form or another, and it's considered a necessary part of the form because it's the attestation by an individual that they're telling the truth.
And do you see the sentence here that begins, "I have attached"?
Yes, that was a recent addition. I say recent, meaning within the last 5 or 10 years. The judges were concerned that people were just not getting it right or being accurate. So a requirement was added to the form for the 3 most recent pay stubs of an individual to be attached, because a lot of people don't get it right. And either they get the math wrong or they don't remember something. So it was considered important by the judicial members of the committee that redesigned it to get some backup documentation submitted along with the form.
So in a family court proceeding, if someone were filling out this document and providing it to court, would they be expected to provide their 3 most recent pay stubs along with this form?
Yes, that was, again, something the judges very distinctly wanted added.
And I'm going to briefly publish what's been admitted as State's Exhibit 1. And first, do you recognize the type of document we're looking at here?
Sure, it's listed as court minutes, and that appears to be a printout of the minutes from court. They're notes taken by a judicial clerk, like one of the people sitting over here on the side, and or it can be written by a judge if it's a minute order. And it's a recordation of what transpired at a given time and place in court.
Okay. And is this one of the documents that you reviewed when you were hired regarding this case?
I believe so. I reviewed the file was considerable, and I looked at a number of minute orders from a number of hearings and a number of different lawyers involved. This appears to be one involving Mr. McDonald and Mr. Cabana, who was one of the lawyers who appeared in this case. As I mentioned, sometimes you can be represented for part of the case and not represented for another part of the case, and I believe that's the history that we're seeing.
And what is the date of these court minutes?
It purports to be March 16, 2018.
Okay. And for what case?
McDonald was the yes.
And would you mind just providing the case number as well?
It appears to be D15-518905-D.
Court's brief indulgence. I will pass the witness.
Mr. Willick, thank you for coming down and sharing your vast amount of experience and expertise with us.
I have just a few general questions.
And without boring the jury and getting into too arcane a point, family court is equity, correct, sir?
In part,
And equity is a little different than law. A judge has a lot of authority in family court to do what a judge thinks is fair, correct?
and according to the court of law and equity, yes.
Law and equity. So things that a district court judge down here downtown can't do or is far from doing, a family court judge can kind of lean into things and do things a little different than most.
I'm not sure I understand the question.
Equity, sir. The
Well,
judge
I'm
has a
not
lot of
saying
power
that
to do what's fair.
I'm certainly not going to say that a district court judge sitting at the RJC is prohibited from ever applying equitable principles.
I understand, sir, but without, I don't want to get overly arcane here. A judge can order someone to move out of a house in family court, correct?
That's one of the things they can do, temporary possession of a house. Yes.
Okay. A judge can give custody to children, correct?
Give is probably not the
Assign temporary custody. I don't know.
temporary or permanent, yes.
My purpose here, sir, is not to spar over picking on words. I'm trying to get the principles out here. Okay? So a family court judge has a lot of power over people's lives.
Discretion is how I would describe it, yes.
A lot of discretion. Okay? And there is no jury sitting in family court. So a family court judge pretty much can only be checked on appeal, correct?
Checked.
Checked. If the judge, say the judge just is having a bad day or makes a blatantly wrong ruling, the only thing a person can do is appeal.
Yes, that's totally accurate.
All right, so So if you're stuck in front of a judge who's not doing a particularly good job, you're in a tight spot, correct?
Again, that's a bit of an overgeneralization, but okay.
All right, now let me ask you a few questions, sir. What's a Rule 11 sanction?
Rule 11, there's a set of rules called the Nevada Rules of Civil Procedure. Rule number 11 is a rule requiring, certifying that the person submitting a document to a court has researched the applicable law, researched the applicable facts, and is certifying that to the best of that person's knowledge, the law presented is correct and that the facts are accurate.
All right, now, a few moments ago, my colleague drew your attention to a document, a financial disclosure form. Remember that, sir?
Yes.
And you pointed out was somehow made evidence private. You helped at least partially create that document.
Well, again, not this version of this form, one of its grandfathers.
All right. Now, family court, as you pointed out, drags on. People can be in court for quite a number of years, correct?
Not every case, but yes, it can.
All right. And people's fortunes go up with jobs, they fall down with the economy if they get unemployed. People's financial circumstances change, correct?
It can.
All right. Now, have you ever been down in the self-help center?
Many times.
Okay. Where would it tell me, as someone who's in the self-help center, how often I have to adjust my financial statement?
If you're asking what's posted in the self-help center, I can't tell you what's on the walls at this moment, but one of the rules that we have had forever and have revised in 2016, and again most recently in the committee that I'm on now, is a rule stating that you have to file a new financial disclosure form if any circumstance has changed, or even if nothing has changed, that you have to certify that basically every 6 months.
And you certainly know that.
Yes.
Okay. And I would imagine any licensed attorney who practices family law would know that as well, correct?
Okay.
All right. Now, what percentage of people down in family court are by themselves?
I haven't seen the most current statistics, but something like 60 or 70% on at least one side.
60 or 70% of the people in family court are representing themselves. And no one's allowed to give them any meaningful help because that would be practicing law.
Well, that's not accurate.
All right, let me ask you a few questions, sir. You are the expert of family court, correct?
I wouldn't say I'm the expert in family court, that'd be a little pretentious, but I have been certified as an expert, yes.
Well, they sought you out, did they not?
They,
All right, well, let me talk to you about the district attorney's office.
yes.
All right, let me ask you a few questions. A district court judge in family court has a lot of powers to discipline litigants, correct?
Yes.
All right, what are some of the powers a district court judge in family court could do if a litigant's being recalcitrant, dishonest, deceptive, non-compliant? What are some of the powers a district court judge has?
Contempt is the most obvious one.
Contempt. And without getting too subtle or too detailed, what is the power of contempt that a district court judge in family court has?
It falls into two categories, civil contempt and criminal contempt. Civil contempt is considered coercive contempt. For instance, if somebody is supposed to be paying child support and doesn't, they can be held in contempt until they pay the child support that they're supposed to be paying.
And before we get too far along, I want to make sure when we talk about civil contempt, we're basically talking about someone being held in jail.
That's one of the things that can happen. There can be financial penalties, there can be injunctive relief, in other words, you must do X, Y, Z, or there could be punishment, but then you're crossing over into criminal contempt.
In criminal contempt. Now, what is the difference between criminal contempt and civil contempt?
One is coercive, as I said, trying to get people to do what they're supposed to be doing that they've been ordered to do, and the other is punishment for not doing what they were supposed to do or doing something they weren't supposed to do.
And I'm going to think, based on your extensive experience in this field, you've seen a lot of people get held in contempt or sanctioned by the court.
Sure.
And even rational, otherwise good people get emotionally involved in their divorce, don't they?
Some.
Okay, so there's occasionally, you've seen contempt powers used.
Oh, yes.
Absolutely. So that's a kind of almost an everyday thing for a district court judge to regulate their own courtroom.
I wouldn't say every day, but sure, it's common.
If I were a judge and I suspected a guy has now got a job when he didn't have a job, would that be inappropriate for a judge to ask him to update his financial disclosure form?
No.
Simple statement of, hey, this looks like it's out of date. You look like you're dressed a lot nicer than you were last time. You got a job now? That's certainly within the power of the court.
Typically, judges don't do individual examination, they leave that to the other party. But can a judge ask a litigant a question? Sure.
All right, and certainly you've been sent, you've seen people get sent home to go do a better job on their paperwork, correct?
All the time.
All the time. Now, besides civil contempt, criminal contempt, asking for updated forms, what other powers to discipline litigants does a family court lawyer have?
Referral to prosecution.
Referral to prosecution. Okay? So if a district court judge says, you know, I think that guy is really out of line, I'm going to send this over to the district attorney's office.
That's a power that a district court judge has, as the ethical rules indicate that both lawyers and judges have an obligation to look out for the propriety of proceedings and to take actions if they see something incorrect.
Okay, so district court judge has got literally a palette of things they can do. I can ask for updated forms, I can send people home to get better paperwork, I can hold them in civil contempt, I can hold them in criminal contempt, and if need be, I can send the case over to the district attorney's office.
Okay.
And there are 3 or 4 different divisions of the district attorney's office as well. Family support, there's the criminal division, correct?
Amongst others, yes.
All right. So my question for you, sir, is in 40 years, with all this power of a district court judge to discipline litigants, why is a Metro detective getting on a website and doing an independent investigation?
Objection outside of this witness's personal knowledge.
He's opened the door.
Counsel approach.
Counsel, your appearances for the record.
The court has a few comments before we begin.
We are on the record in the matter, case D-505.
You guys either agree or I order.
You're going to convince me to hold your client in contempt.
Raise your right hand, face the court clerk to be sworn. Gentlemen, we're going to take a short
short recess. During this recess, you're admonished, do not talk or converse amongst yourselves or with anyone else on any subject connected to this trial, or read, watch, or listen any report of, or commentary on this trial, any person connected with this trial, by any medium of information, including without limitation, newspapers, television, radio, or internet. Do not form or express any opinion on any subject connected with the trial until the case is finally submitted to you. You can take 10 minutes.
Please rise for the jury.
First of all, as to the question, your objection as to, I believe it was relevance, how is this relevant, whether he knows why the DA did anything?
What I have, Judge, and the court, is the way this matter is being broadcast live, there are two factions of political operatives in family court. One group is called Nevada Court Watchers, and there's another one called Court Observers. They are at war with each other. I don't go to family court. I hate it down there, Judge. This is not what I wanted to do. I'm sorry, I have to go here because this is where the law takes me.
All right, tell me how.
Specifically, last night when I was preparing cross-examination on what I thought was going to be a casual expert witness, it was brought to my attention a Mr. David Schoen not only watched the proceedings here in court over my objection, was able to comment on my cross-examination, and then added the interesting insight on this Nevada Court Watcher site that says, quote, Mueller's questioning regarding the anonymous source who posted McDonald's candidacy records is just conspiracy BS. I, Mr. Schoen, was one who paid for and obtained these records from the electoral department and gave them to Mark, quote, DeCiro, to post on Nevada Court Watch. I also pulled Sanson's records, that's a man in the back of the courtroom, and to those everyone else was running against me in my assembly race last year. Now, Mr. Schoen, not surprisingly, is Mr. Willick's fiance's employee. Mr. Willick is actually the one who's involved in getting this charge filed. May I approach? This stuff is so sordid, Judge, it makes me sick to my stomach, but these people are absolutely effing nuts. It is hard to imagine as an officer of the court, after 25 years, I've got to deal with this sort of immature behavior. But this is what's on the website. And since the detective yesterday could not explain how he got an anonymous source on a software that does not allow you to post anonymously, the detective is either deeply mistaken or lying. Now, I've got literally 5 or 6 more posts about these people, and they're just sordid behaviors. Now, they have framed Mr. McDonald because they don't like him. They framed Mr. McDonald because he's in litigation with Mr. Sanson, and I have nearly definitive proof that that's the case. Now, I've never seen a case like this. I've objected at every single turn. I've objected to this damn camera, and now here I am having to do a cross-examination on this sordid behavior of family court. These people are loathsome.
This back. So you're saying that and we're only at this point talking about the question you asked, whether he knows why the detective did an investigation?
She's objected to the first question in my line of questioning. What I'm going to believe, the answers are going to believe, is that the detective was actually asked to, or someone specifically adversely hostile to Mr. McDonald and Mr. Sanson posted this information. You may recall my incredulity, my amazement that the investigation didn't stop when they found out that he lived in his district. But that didn't stop because that wasn't the purpose of the investigation. The purpose of the investigation here is to punish Mr. McDonald for his ties to Mr. Sanson. This stuff is as sordid and as disgusting as it could possibly be. And I turn around and every time I don't want to have to deal with this stuff shows up. There's 40 pages of this stuff.
State
And Your Honor, any connection between this witness, Mr. Willick, and the detective is extraordinarily tenuous. I don't know if Dave Schoen actually has a connection to Mr. Willick that defense counsel claims he has, but even if he does, it's extraordinarily tenuous.
Who is Mr. Schoen?
Mr. Schoen
who
is,
defense coun-
Mr. Schoen
Can I talk now? I
Certainly.
didn't interrupt you. Mr. Schoen is the person that Mr. Mueller is contending, based on this Facebook conversation on the Nevada Court Watchers, posted information regarding Mr. McDonald's candidacy on the Nevada Court Watchers site, and is stating he's the person who made that information available on the Nevada Court Watchers site. Detective Stanton's testimony was that he observed this posting. He did not recall who made the posting, and he testified that it wasn't a direct communication to him. He was monitoring Nevada Court Watchers, saw the posting, and that's where he initiated his investigation. And there were actually two different postings that Detective Stanton observed on Nevada Court Watchers that led to his investigation. One was the posting referred to by Dave Schoen regarding, apparently recorded to by Dave Schoen, according to the Facebook site, was the posting about Mr. McDonald's residency. But Detective Stanton also reviewed Nevada Court Watchers shortly afterward, and he saw another tip he didn't recall, or another posting he didn't recall who posted it, indicating that Mr. McDonald may have posted a forged document, and that was actually more directly related to the investigation that Detective Stanton took. So this connection here is just extraordinarily tenuous, and still it doesn't establish that this witness can testify why Detective Stanton did what he did. There's no connection between them.
We just elicited testimony from their expert witness on all the manifold powers granted to a district court judge using their equitable powers in family court. And yet I'm here having to defend the extraordinary proposition that a 25-year detective went down and started randomly reading divorce files for no particular reason. Then when I'm confronted with this mystery, I now have it answered. Mr. Willick's fiancée, this is his employee. This is his confederate. This is Mr. Willick's confederate has done this. And Mr. Willick, who gets $10,000 or $20,000 retainers, is down here on a Friday morning at $150 an hour for no particular good reason other than the goodness of his heart. Now, this is a political prosecution through and through.
All right, anything else?
No.
Thank you. All right. I will allow you to inquire of Mr. Willick if he knows anything about Detective, I forgot his name now.
Stanton.
His investigation. But your characterization of the detective's testimony is wholly inadequate. You're forgetting the fact that the testimony, in my mind, and the jury certainly is the one who's going to decide this, was that the posting, the initial posting started, but his investigation lasted, or initially was over, I thought he said, weeks. And then there was, in the interim, the second posting regarding the other, and he hadn't done the search warrant yet, etc. But in any event, that's part of the court record. I'll allow you to ask if he knows or heard of the detective or knows anything about the investigation, but asking why, again, we're getting back to why the objection, asking why Detective did his investigation, I'm going to sustain the objection. How they're asking him to testify regarding what was in the detective's mind, and he's already testified as to why. But if you want to ask if he's ever talked to him, if he knows why he did, if he knows anything about the investigation, I'll allow that.
You did.
All right. Because I assume it's going to come up, questioning regarding his fiancée, tell me, his fiancée's employed?
Yes. David Cohen works for his fiancée. Direct employee of Mr. Willick's fiancée.
And what does Mr. Willick's fiancée do?
She is a family court lawyer.
In the their firm or another firm?
A different firm from my understanding, Judge. I do not practice in family court, and I do my best to stay out of it.
Okay, I get that, and I certainly, that's a different area, I don't know much about it, but, in any event, all right, we'll wait and find out what questioning you, where you go. I would certainly, this is far afield of the charges, and, unless you can draw some connection, what happens on the internet, hopefully, is not getting to the jury. And the relevance, I think you're once again trying to draw the conclusion that this is somehow driven politically. And again, other than individuals may or may not be agreeing or like or whatever, it doesn't appear to have anything to do with the state intervening or taking any action that would be prohibited by the case law. Okay, thank you. Take a few minutes to look where they are, and we'll come back and hopefully go through till lunch. Please be seated. Parties acknowledge the presence of the jury. Go ahead.
Here, before we took a break, I was asking you about ways that a district court judge and family court could discipline litigants. And we've gone through this, contempt, documents, criminal offenders, literally a whole panoply of things that a district court judge could do.
Sure.
Now, in 40 years, and I'm sure practicing law, we all see a number of crazy things. But realistically, sir, have you ever heard of or you're familiar with a intelligence detective taking it on his own initiative to start reading divorce pleadings?
Oh, sure.
Intelligence detectives reading divorce pleadings.
Several prosecutorial authorities, state and federal.
Several.
Yes.
Okay. How many cases get filed down in family court every year?
I have reviewed those statistics, but I don't have them memorized. It's thousands.
Hundreds of thousands?
I don't think that many in a year.
Okay, so over a 40-year career, well, you've been down there and you've been the guy to go to in Clark County District Court. Say thousands, you've been there for 40 years. We're talking at least a couple million divorces going through that courthouse, correct?
Probably.
I mean, without even exaggerating, we're talking a couple million files, correct?
It very well could be. As I said, I haven't reviewed the math recently.
All right, now, we all know Las Vegas is a relatively still small city, even much larger than it used to be. So you kind of got to keep a pulse on things or gossip and things, what goes on in the courthouse, correct?
I'm not sure I followed that question.
Well, sir, it's a relatively small courthouse down there, family
There
court.
are 20 family court judges right now, to be expanded by 6 in the next 2 years.
All right, so it's fair to say that you make it a point, or even if you don't want to, you kind of hear the social talk of the courthouse down there?
Objection, this line of questioning is calling for hearsay.
Yeah, asking hearsay, I'm just trying to get a feel for what she called him as an expert on family court, and that's fine, I'm just trying to understand how it operates.
All right, I'll allow it.
All right, it's a small bar down there. You guys kind of all know each other, the attorneys know each other?
Sure.
All right, and when you're not talking about cases, you're on breaks, you kind of talk to each other.
Some more than others.
Some you get along with, some guys you don't, I understand. But I mean, you kind of get a feel for things.
Sure.
Now, in the millions of cases that have gone through that courthouse in your 40-year career, how many of them have metros gone through a divorce proceeding on their own initiative? That's pretty rare, isn't it?
Objection, relevance.
It's rare in his experience, that's why he's here.
I think you're asking him about, I'm sustaining the objection.
Right, I'll rephrase them. Thank you, Judge. Sir, you know of any of those? You been involved in a case like that?
Could you make that question a little more specific? I'm not sure I followed you.
A Metropolitan Police Department on his own initiative comes and investigates one of your files.
I believe that has happened, yes.
You believe it has, or it hasn't happened?
I'm pretty sure that it has happened in some of my cases, yes.
All right, and have you requested them to do that?
I have seen requests from lawyers, judges, justices,
But that wasn't my question, sir.
Have I?
Yes.
Yes, I believe over the years I have asked Metro to investigate.
All right. Now, who is David Schoen?
David Schoen is an employee of another law firm.
All right, and in fact, it's your fiance's law firm, correct?
Yes.
All right, so you know Mr. Schoen fairly well.
I wouldn't say that. We spend relatively little time together, but I know who he is.
All right. Now, I want to go through a few basics here, sir. This organization that you're involved with, Nevada Court Watchers,
I wouldn't say I'm involved. They have a website, which is one of many that I read.
okay? And the fact that you were on the Nevada Court Watchers last night for the admin log, you actually logged on it yesterday, correct?
It's on my regular feed, yes.
Okay. Now, did you read Mr. Schoen's report that he was the one who gave the
Objection, introducing hearsay.
Did you read the report from Mr. Schoen?
I'll
Objection.
sustain it as to what's in it. Did you read it?
Did I read Mr. Schoen's posting yesterday that he supplied information relating to that? I'm sorry, I'm trying to understand. I'm sorry. I did read Mr. Schoen's posting yesterday.
Now, since you're familiar with Nevada Court Watchers, is it possible to post on it anonymously?
Not that I know of, I don't think so,
So if someone thought they'd seen an anonymous tip, they would be mistaken?
probably.
Now, do you know why Mr. Schoen would be posting regarding Mr. McDonald's case?
Objection, lack of personal knowledge of the other person's
Right.
motives.
Let me ask you a question, sir. Your organization, Nevada Court Watchers, is one...
Objection, misstating testimony.
Do I? Okay.
Sustain.
Nevada Court Watchers is one organization composed mostly of family court lawyers.
No,
No?
no.
What is Nevada Court Watchers?
I believe it's got a couple hundred members, the great majority of whom are simply members of the public. Lots of people have posted on it. Mr. McDonald's posted on it.
Well, actually, sir, I printed out the list this morning, and it appears to be almost all family court lawyers.
I don't think so.
All right. Is there another organization that keeps track of what goes on in family court?
Many.
All right. Have you seen, or are you familiar with an organization called Court Observers?
By that name, I'm not sure.
Mr. Sanson's group, sir.
I know that.
Okay, and what is the name of that group, sir?
Mr. Sanson is the titular head of an organization called Veterans in Politics, supposedly international.
Yes, sir. And what, to the best of your knowledge, does he do down in family court?
Objection, relevance, why is
Yes, come in.
Mr. Sanson's activity?
Because he's related.
Counsel approach. I sustain.
Sir, you've met Mr. McDonald in the past,
Yes.
and why did you undertake this representation? If you're an expert witness, you've got personal knowledge.
I don't have much. I've met everybody involved in the case. Anybody that has touched family court in any significant way over the last 20 years, I've probably run into. That's what I do. It's where I work every day.
All right. Now, then how come you couldn't remember how many times Metro's independently investigated cases?
I've never been asked that question. I've never done any research.
Now, would you use, or has it been used, in your experience, have lawyers used the criminal process to gain advantage in family court?
Has any lawyer ever used the criminal process to gain an advantage in family court? I'm sure it has.
Okay, sure it happened. Have people occasionally, in fact, some lawyers occasionally get bad reputations for having their clients report domestic violence?
I don't think I followed that question.
All right, sometimes if one party is accused of domestic violence, it gives them a leg up in court, correct?
There's a popular conception that that's used as a tactic, yes.
All right, a popular conception. So that is a thing in family court.
It's perceived as a thing. It happens, I think, less often than the popular conception would have. I have worked as a domestic violence hearing master for years as a pro temp, part-time job, and I have seen lots and lots of domestic violence filed.
And you have a suspicion, at least, it's a perception, that sometimes they're less than candid.
No, that wasn't what I was saying. I'm saying that the popular misconception that they're used tactically is not terribly accurate in my personal experience. I'm sure it's happened.
Okay.
Everything's happened.
Now, you know Mr. Sampson, obviously you just mentioned, correct?
Yes.
Is Mr. Sampson associated with Mr. McDonald?
Yes.
All right, and you and Mr. Sampson are litigating against each other.
Protection, relevance?
Yes.
All right. And when did that litigation start, to the best of your recollection?
Oh. I don't know, 2014 or 15, I think.
2014 or 2015, and his, Mr. McDonald, you said you did look at this paperwork?
Which people?
This, the divorce paperwork that my colleague asked you about a little earlier? She handed you 4 or 5 exhibits?
Yes.
Okay. And Mr. McDonald actually filed for office, and do you remember that?
Yes.
Okay, do you remember when that was?
No.
All right.
Sometime in the last couple of years.
And as you sit here now, sir, you familiar with anybody else in family court that's been charged with a crime?
Sure.
Okay, after running for office?
I'd have to go back over many years of records. I don't have any idea if any of them have run for office.
We have the court's indulgence for just a moment. Judge, or Mr. Willick, thank you for your time and expertise, sir. So I did have one other point I wanted to clarify. Civil contempt versus criminal contempt.
Yes.
District court judge's powers done in family court. What is the difference? And make sure we understand that clearly.
Civil contempt is primarily coercive contempt. In other words, trying to get somebody to do something that they're ordered to do or stop doing something that they've been ordered not to do. And it's used as a means of trying to get them to comply. It's the common rewording is you have the keys to the jail cell in your hand. Criminal contempt is basically punishment for something that you've done that you shouldn't have done, or for not doing something that you were supposed to do.
Okay. And what is there a limit on how much civil contempt versus how much criminal contempt can be imposed on a litigant?
There's a lot of rules. Rules relating to appointment of counsel, rules relating to maximum sentences, yes. I don't have them all memorized, but yes, there are rules.
All right, there are rules. All right, thank you, sir. I have no further questions.
Redirect.
Just briefly. So, Mr. Willick, do judges in family court typically investigate claims made by their litigants on documents filed in family court?
Well, judges basically don't do any independent investigation at all, not in the American system, unlike, say, the French system, where the judges are charged with doing individual investigations. They don't do fact research at all. They do legal research, but not factual research. They're supposed to go through other means to get stuff presented in court.
And I want to ask about the financial disclosure form that we were talking about before. And you stated that that's available at the self-help center. Is that the only way that a family court litigant can get that form?
Oh, no. It's posted on my website. It's on the Self-Help Center's online website. It's floating around all over the internet. It's widely available.
And these places where it's available on the internet, are there also instructions for how to complete it?
Oh, yes. Discussions, instructions, guides, sure.
Okay. And do those instructions say anything about needing to update the form when one's financial status changes?
Again, it's evolved over the years, so it probably depends on which version you're looking at. The instructions will have information about that on it, and it's in, of course, the local rules.
And are you familiar with a program called Ask a Lawyer?
Very much so.
Okay, what is that?
Ask a Lawyer is something that legal aid came up with that allows anybody that wants to show up on Thursdays in the afternoon and have a 15-minute consultation for free with volunteer lawyers. I'm one of the people that participate in it. I've been involved with legal aid for many years, so yes, it's something that we do, the lawyers do, to try to give free legal assistance to the public.
And it's something like that, can these litigants get assistance in completing their financial disclosure forms?
Happens every week.
Okay. And so do people get advice and assistance regarding family court matters?
You got it.
And, okay, and you were asked some questions by defense counsel about Steve Sanson.
Yes.
Okay. And does your knowledge of Steve, or does your interaction with Steve Sanson and the apparent litigation, does that have anything to do with Mr. Michael McDonald?
Does my litigation with Mr. Sanson
Yes.
have anything to do with Mr. McDonald? No, it's not involved, as far as I know, in any way at all.
Have you had any involvement in referring Mr. McDonald to the Las Vegas Metropolitan Police Department for prosecution?
No.
Or its brief indulgence? I'll pass the witness.
Nothing further.
Questions from the jury? Raise your hand. All right, we have one that was counsel approach. Mr. Willick, in your experience, how often does a judge send a case to criminal court?
It's rare, but it has happened many times over the years. I've seen it several times.
Follow up from the state?
No, Your Honor.
Follow up from the defense?
And I know you've done this an awful long time, the cases probably run together a little bit, but do you remember a specific occasion?
Sure.
Okay. What kind of things happened to get you sent to criminal court or family court?
A particularly notable example would be the Vail case. Robert Scotland Vail kidnapped his kids from Norway. I was the attorney appointed by the National Center for Missing and Exploited Children to try to recover them. And after a long legal battle, we eventually did. The case worked its way from family court up to the Nevada Supreme Court. And it was discovered that Mr. Vail had submitted a falsified affidavit of residency. That was part of the court record. And his lawyer had submitted what I believe the court characterized as a too cleverly worded affidavit of residency, indicating essentially fraudulently that Mr. Vail was a resident of the state of Nevada when he wasn't. The final opinion from the Nevada Supreme Court was a 4-3 split decision, and the dissenting justices, on the face of the published opinion, referred the attorney for investigation to the bar and Mr. Vail to the district attorney for prosecution for falsifying his affidavit, his residency affidavit.
So the case that referred to the district attorney's office was documents supported fraudulently to support a kidnapping?
No. Well, no. The affidavit of residency was for the divorce itself. The kidnapping was 2 years later.
All right. Thank you, sir.
Thank you. You may step down.
Thank you, Your Honor.
State, call your next witness.
The state does not have any more witnesses, and actually at this point, the state will rest.
Thank you. Defense.
May I have a moment to us at presence of the jury?
Sure. I'm sorry, you got, oh, okay. We'll take a short recess. During this recess, you're admonished, do not talk or converse amongst yourselves or with anyone else on any subject connected.
All right, thank you, Your Honor. This is not your typical eyewitness identification robbery case, Judge, and it has been a challenging representation, but I do believe that several of these charges should be dismissed at this point.
Mr. McDonald, please be seated.
But I mean, there's a number of burglary counts. Specifically, count 1. Needs to be dismissed. Specifically, it says the state's complaint is did on or about the 4th of December willfully and unlawfully enter with felonious intent. There has been not a scintilla of evidence as to Mr. McDonald's intent. The state has established that he has been in the courthouse. That's not in meaningfully in doubt. He's had to. That he entered on that particular day with felonious intent or what was in his mind is not, there's not a scintilla of evidence. The additional evidence that has come to light in the intervening evenings and this morning was that Mr. McDonald also was frequently in the courthouse as part of something, an organization called Court Watch. The fact that there's a picture of him in the courthouse does not support a burglary charge, and the state has actually adduced no evidence to support that. So I'm going to respectfully move to dismiss count 1, burglary. Number 2, the counts forgery. Now, forgery is the crime of passing off a document as false document as genuine. Forgery requires an element of intent to defraud. If I'm out of my office and I tell my staff to write a letter or read it back to me over the phone and I tell them to sign it for me, they have permission to do so. If my staff then passes that letter off with my signature on it, though it's not genuine, that is not a forgery, and it is not a crime. Now, reasoning by analogy, I'm sorry, her name escapes me. What was the test? Ms. Hunterton testified that A, Mr. McDonald did in fact approach her for a letter, that B, Mr. McDonald had been in testimony with her, C, that Mr. McDonald did in fact, as a pro per litigant, ask for a letter documenting that it was her opinion that he was not a threat to his kids or his family. D, she agreed that he was not, and other than she quibbled with the text of the way it was written, substantively adopted that opinion as her own. Therefore, if Mr. McDonald put a document off without it being genuine, but in fact without intent to defraud, which there is no intent to defraud, there can be no forgery. Now, every single day your staff stamps your name on documents, so you have copies and several copies. That doesn't create an intent to defraud, even if they get busy and didn't show it to you and they inadvertently signed it. It is an intent to defraud is when a document is passed with an intent to deceive, not when a document I believe is factually accurate in support of my case is factually accurate, if procedurally slightly irregular. So I do not believe the element of forgery or 3, filing a false statement for that document can be sustained past this point going forward. That brings us back once again to count 4, offering false statements, instructions. The same letter that was actually factually accurate is not a false statement. Then we come to burglary again. And my colleague can address the court. I did not see a scintilla of evidence enough to go to the jury on whether there was a burglary committed on the 13th of March. Now, there is Mr. McDonald's circumstances changed over time. He was unemployed, he was employed. He ran for office, he got thrown in jail, he got arrested, he got a new job. And so the fact that the financial affidavit is not updated is the fact that the document's not updated. Mr. Willick, the state's own expert, said the judge can order updated statements. This doesn't look accurate. You need to update this. This is too old. You need to update that. There's not a scintilla of evidence that it was fraud or forgery or false document. It may have been a stale document, but it's not a crime. And so respectfully, I believe count 4, burglary, should be dismissed. Count 5, forgery, should be dismissed. Perjury. Well, once again, I am very uncomfortable and have been very uncomfortable with this entire proposition that a pro per litigation, and remember, family court is the only court you can't avoid. You've got to go there. Some woman drags you in there because you have kids with her, she doesn't want anything to do with you. You can't say, no, I'm not going. You have to go. And where his attorney kills himself and the money he had set aside for an attorney, now he's gotta do it all himself. Now, I'm asking with the straightforward to all of us in this room, are we really gonna throw proper litigants in prison for not necessarily handling a complex piece of litigation? I'm very uncomfortable with this whole case, have been from the start, I have not been subtle about it. Once again, I'm going to renew and move to dismiss the perjury count. There's been no showing that it later turned out to be unsatisfactory. The state is a different mental state than perjury. Perjury is when I go up there and I know that the car that escaped with the suspect was red, and I say it's blue because I want to help my buddies. That's perjury. When I know I'm lying, that's perjury. When I put my paperwork as best I can and turn it in and I don't update it, that's not perjury. Now, filing a false statement. Once again, we got count 7, filing a false statement. The state has, there's a known element here. The state has to know. Now, if the state wanted to prove a false statement, and they had a videotape of Judge Marquis saying, go back and file this, Mike or Mr. McDonald, this thing's 7, 8 months old, I don't think it's accurate. I'm gonna give you a week, you're gonna come back here with a corrected statement. And he came back then with a false statement, that case pleads out, all right? But that's not this case. The state has not showed that there's any notice of intent. And we actually checked the statute, there's an intent notice here on filing false statements, perjury. Once again, no mental state here ever at all. Burglary on the 21st of March. How do we know he was there? He might have been there with Steve Sampson to check out on the court. They've got a videotape of him sitting in the courthouse. Okay, well, what's his intent? You have to intent. Now, the burglary statute in Nevada, as you know, is a chop shop. I call it chop shop burglary. Entry with intent, dwelling place of another with intent to permanently deprive. Those were the 5 elements under common law burglary. It had to be at night. Nevada got rid of all 3 elements. You have to go into a building with intent to commit a crime. Well, we used to use that against the homeless guys who would steal the coins from the little old ladies downtown at Fremont Street. Because they would go in there, they didn't have any money, had any ID, and they just took the ladies' purses, or took their coin purses. However, this case and this record is completely devoid of what was in fact Mr. McDonald's mental state. Why are we going in here? How do we know he wants to commit perjury or burglary? I mean, well, I guess I should address each one of these, but for the record, perjury, then we got count 9, once again, burglary. The state has adduced none of Mr. McDonald's mental state at any time he entered in that courthouse. Count 10, forgery, specifically. Again, we're talking about this statement from Ms. Hunterton, apparently on a different date, this time on the 31st of August. They haven't even established that. And filing false official statements for the record. Once again, I don't believe that they've got enough evidence to go to the jury on any of these counts, Judge. I respectfully,
Thank you.
and Mike, this is why you got yourself sitting here. Okay, keep your mouth shut. Now, the answer is, Judge, they've also overcharged him. He actually turned in the original document at one point. 3 of these counts, one of the burglaries, one of the forgeries, and one of the false official documents need to be dismissed. The reason, because originally he turned in the statement from Hunterton and then had it added later. So at one point, the occasion, and I guess it's up to the state to establish, there's 3 of those that should actually be dismissed because he actually turned in the actual document on one occasion. So, Your Honor, I'd ask to dismiss this case.
Okay,
Thank you, Your Honor. First, the state does not believe there's any statutory basis for defense counsel making this oral motion at this time. At this point, he could make a request for an advisory verdict from Your Honor, or if the defendant but it needs to be left to the jury to render a verdict, and certainly the defendant, if found guilty of any of the charges, would have the right to appeal, and he did claim there was insufficient evidence. Regardless, I'll address his claims on the merits. Regarding burglary, in Nevada, at this point in time when these crimes were committed, burglary is defined as entering a room or building with the intent to commit a felony therein. That's how he's charged. That's how it is charged. In this case, he's charged with 3 counts of burglary. one on December 4th of 2017 for entering the clerk's office on the 3rd floor of this building, room 3317, with the intent to commit forgery and or offering a false instrument for filing a record. First, regarding entry, there has been sufficient evidence that he entered that room on December 4th. There is a surveillance photo entered into evidence showing he was in this building on that date. We have the testimony of Christina O'Connor, who testified that that particular document, the December 4th, 2017 filing, was filed in person at the clerk's office in this building. Additionally, intent, the case law states that a defendant's intent can be inferred from his conduct and the surrounding circumstances within the case. In other words, what a person does tells you something about what that person intended to do. The defendant does not need to be aware that the particular actions he's going to take are felonies. Ignorance of the law is not a defense, but in this case, the state has produced sufficient evidence that he did in fact commit forgery and as well as offering false instrument for filing a record upon entering the clerk's office on the 3rd floor of this building, because he then filed the forged document. And similarly, March 13th and March 21st, evidence has been introduced that the defendant entered the family court building at 601 North Pecos and filed these forged documents. On March 13th, he was actually seen in the building by Timothy Spees in the reading room, which is where these documents are filed. And again, regarding all of these, regarding all of the burglary counts, intent can be inferred from conduct. And in addition, intent is a question for the jury. It's not for this court to substitute its own judgment regarding the defendant's intent in place of the jury. And regarding forgery, any person who falsely makes, alters, forges, or counterfeits any record or any document or paper recorded or filed in any court with the intent to damage or defraud any person or persons is guilty of forgery. Additionally, any person who passes or attempts to pass as true and genuine any false, altered, or forged record or any document or paper recorded or filed in any court, knowing the same to be altered, forged, or counterfeited with the intent to prejudice, damage, or defraud any person is guilty of forgery. Both of these definitions of forgery contain the word alter. That's what occurred in this case. By altering the letter from Nancy Hunterton, it then became a forged document. And he passed off this document as true by filing it in the family court on 3 occasions. Regardless, the state doesn't need to establish that the content of the added sentence is in itself false. This became a forged letter as soon as that letter was added. The letter that has been introduced into evidence, what the defendant attempted to pass off as true, is not the actual letter that Nancy Hunterton wrote. It contains her signature. He added an additional letter. As soon as he did that, that was no longer actually the letter that Nancy Hunterton gave him, and he passed it off to the court as though this entire letter, including that sentence that she did not write, was in fact the letter that she gave him. It was not, so it is false for that reason. Additionally, defense counsel is somewhat misstating the testimony, because Ms. Hunterton repeatedly stated that if she might express that sentiment, but not in one particular sentence. She would want to include additional conditions and limiting information. Regarding perjury, I'm kind of shocked that defense counsel is actually able to say that there's no evidence of this. Though the defendant may have filed a financial disclosure form at an earlier date, the financial disclosure form here that was filed related to that count of perjury contains the defendant's signature, and next to that is a date that says March 13th of 2018. And during his testimony in family court, the defendant acknowledges that the information on that form is regarding 2018. He never says, oh, I just refiled the one from 2017, and he signed it with a more current date of March 13th of 2018. And this isn't a case of some small typo. The form requested that he attach his pay stubs. We have his pay stubs from Logistics, and he did not attach them. He filled out a form claiming that he had 0 average monthly income, and then at another part he said his total income was about $800, when in reality every pay period he was getting about $1,800 and was a salaried employee. So he, even if this was just the exact same information he'd submitted back in September of 2017, when he was unemployed, he represented that it was current to the court by citing under penalty of perjury that it was true and accurate to the best of his belief. And he did that in March of 2018 when he was employed. Further, none of these statutes that defense counsel has referenced, these offenses with which the defendant is charged, none of them have family court carved out as an exception. It's true that tempers run high in family court, but there's no special exception for committing forgery or perjury or any sort of fraud-related crime just because it relates to family court. Additionally, I think defense counsel, and lastly, defense counsel seems to be confused about the timeline of the filings in this case. The defendant on 2 occasions filed the original unaltered letter that was written by Nancy Hunterton. He's not charged with a crime for that. On September 27th of 2017, that is when he originally filed that letter from Nancy Hunterton. That's why he's not charged with a crime for that. There was nothing wrong with him doing that. On December 4th, December 4th of 2017, that was the first time the defendant filed the altered letter. He's charged with a forgery for that. Then December 20th of 2017, he files the original letter again, which is strange, but still not a crime because that was the letter Nancy Hunterton prepared for him and gave to him. He's not charged with a crime on that occasion. March 13th and March 21st of 2018, he files the altered letter that contains a sentence that Nancy Hunterton did not write. So he's charged with crimes that occurred on those dates as well. So the state never charged him with a crime for filing the letter that Nancy Hunterton gave him. And with that, I'll submit.
Thank you. Counsel, there certainly were. Go ahead. This is my question. Statute may allow an advisory opinion, but you're going to a motion to dismiss.
Well, we're the closest state's evidence, and there's absolutely, and my colleague, to her credit, read the court the entire statute, and I thank her for that, but she keeps losing this second column. In all these charges, there has to be an intent to defraud. They've not demonstrated that at all, ever. Now, the court's correct procedure that I'm asking for trying to have my cake and eat it too, and you're right, I'll correct my motion. Your Honor, I would ask for an advisory verdict that the charges haven't been proved, as there are in fact no evidence of intent. Now, we are the close of the evidence. It is the opinion of this officer of the court as defense counsel that there is substantive flaws in every theory of criminal liability, specifically intent. And that if this were a civil case, I know you're a civil litigator, I know you know the decision is to dismiss our 26B motion is here. In criminal law, you do have the power to dismiss for failure of evidence to reach the jury, but standard procedure and under Nevada procedure is an advisory verdict that is the opinion of the court that the charge has not been proved. Was how the other time I've dealt with that issue was in front of Judge Mueller, so it's been a few years. But Your Honor, I don't believe the state should be allowed to go to the jury with this case. I don't believe the charges have been proved. I don't believe there's any admissible evidence or even inference on evidence on the element of intent. And for that and for public policy reasons, I believe the case should be summarily terminated at this juncture.
Thank you. All right. It is, or it should be, a request for an advisory opinion, not a motion to dismiss. But I'm denying the request for an advisory opinion, and here's why. Basically, the defense is asking me to interpose my opinion as to whether or not the evidence is adequate to convict. It is important to note, or I will note, that there is admissible evidence given, and let's talk about the burglaries, there are several counts, entering what they're alleging, if the jury agrees or doesn't agree, is the issue, entering the building with the intent to file the false, fraudulent, etc. documents. And so there are sufficient facts where a jury could, if they believe that the facts are, I guess, one way or the other, that is going to be their decision. As to the offering of the false instruments, the basic theory is that, and I hate to use this as so simple, no harm, no foul. The witness, the Ms. Hunterton, testified fairly clearly that that was not what she would have put in the letter. Whether she would have qualified it, whether she would have, I think she may have said something about conditions. All of that is important to a, certainly I would imagine, to a family court judge. And although she did indicate her general agreement with that particular statement, that clearly my recollection of the testimony is not the totality of what she would have written, and that in that sort of a situation is very important. I have to agree with you. I don't want to. I don't do. That's why I'm here and not over there. I don't do family court, but I certainly can imagine that those statements from a marriage and family counselor as to the issue that was involved are important, and a summarily, if you will, characterization could, and I'm only saying could, be inaccurate as to the overall circumstances, and certainly could be crucial to a determination. They're not, as I said, no harm, no foul, insignificant. That's for the jury to, they've heard the evidence. And as to the perjury counts, I think my recollection of the testimony is that he certainly, meaning the defendant, had been working a full-time job prior to March 13th, 2018, and at least for several months leading up to that had pay stubs. And so a jury could clearly, if they choose to, come to the conclusion that his filing of the affidavit on that date was perjury. Whether, again, you're asking me to, that's why judges do what we do and juries do what they do. But in this case, and I will say, because I have read the case on advisory opinions, it is, I believe, I don't know the exact wording, but the Supreme Court has said it is not to be taken lightly to, if you will, impose a judge's will, if you will, on the process. So I don't take it lightly either way, but in this case, I am certainly finding that it is inappropriate. So packet.
I don't
Well, let me ask you this, have you agreed upon a certain amount of them? I would imagine.
When I submitted my proposed instructions to the court, I CC'd defense counsel, so then they were provided.
Mr. Scheller was, I'm sorry, counsel, I apologize. I'm sorry, Mr. Scheller was working on it for us last night. We got a package. There's actually about 3 or 4 that we're going to add, so maybe we can settle with my colleague over lunch.
Okay, terrific. Then I'll allow, say, an hour, so we'll have them come back at 1:30. And hopefully we'll be done, and you still get a few minutes to get some lunch. Then, and this does take a while, you want, well, it's a question, do you want each of the members of the jury to have a copy? That takes probably 20 minutes alone to get that many copies done.
I would think that's a good idea.
And it's generally done, I just want you to take that into account in the timing.
There is one,
The state would prefer for each juror to have a copy of the
That's fine.
instructions.
as with defense.
Seen it done either way, but that's
Right.
fine.
There is one issue that's going to become contentious, and I'm going to bring it up now before lunch, so.
Well, we're gonna deal with, is it jury instruction?
Well, no, the charging document had left out the key element, the charging of intent to defraud, which is court just heard from my colleagues reading the statute. We've got forgery with the language of intent to defraud is removed from it. We've got a count here, forgery counts do not have the proper language in the charging document of intent to defraud. We also have, I guess it's the charging is forgery counts, and it's also false official. We'll stay with forgery counts. I'm bringing this up, I'm not suggesting we even argue it now, but I would say that the counts 2, 5, and
The forgery.
And Your
forgery
Honor,
counts do
the
not
forgery
track the
counts
statute.
all contain intent to defraud toward the beginning. So that would be page 2, line 4 says intent to injure or defraud. Page 3, line 8, intent to injure or defraud. That's count 5. Page 4, count 10, line 26, intent to injure or defraud.
Yeah, we'll sit down with these with the over the
Okay, thank you, let's bring them in. So,
I left them up there. I suspect defense counsel actually.
Oh, they're right.
Yeah.
all right. You rested on the record, Mr. Mueller wants to rest on the record, and then we'll give them another, then they'll go to their lunch break. And just to refresh your memory, I read to you yesterday the defendant's right to testify.
Yes, sir. Mr. McDonald is going to follow counsel's advice and not testify, not because he couldn't bring something to it. He's not articulate and his mental emotional to be understanding.
Very well.
Please rise to the jury.
All right, please be seated. Parties acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Defense.
Thank you, Your Honor. After consultation and review, this case does not need a defense. The defense will rest.
Very well, ladies and gentlemen, the parties and I will be working on jury instructions, and I will have you come back at 1:30. We'll be doing closing arguments. So, during this recess, you're admonished, do not talk or converse amongst yourselves or with anyone else on any subject connected with this trial, or read, watch, or listen in a report of, or commentary on this trial, or any person connected with this trial by any medium of information, including, without limitation, newspapers, television, radio, or internet, do not form or express any opinion on any subject connected with this trial until the case is finally submitted to you. And you go back into the jury room to deliberate. Have a good lunch.
Is there anybody that has a lunch in the jury?
We're on the record outside the presence. Do you guys want to 20 minutes, 30 minutes, let's say, go get something to eat and then come back?
Yes, sir.
What's the preference?
That'd be
Okay.
great, Ron.
So like quarter after.
All right, sounds good, thank you, Judge.
Okay, so somebody put, is this the only contested?
Yes, Your Honor. Craig Mueller, on behalf of Mr. McDonald. We went through the jury instructions, Mr. Scheller did those, and I was deluged by 25 pages of other material I had to go through last night. The one addition that we want to add, Mr. Scheller recollected, and I agree with his recollection, beginning at line 6, he found that language that's found in Ratsos versus the United States, as a 1994 U.S. Supreme Court opinion, where specific intent to commit a crime or willful conducts are required, ignorance of the law can prevent the required specific intent or willful conduct from being present. And we don't propose that as anything other than addition to the instruction, which is out of the Nevada standard instruction, ignorance of the law is no excuse.
Okay, and that's the only contention of all the, not that, I mean, that's good, that other than that, the state had provided you and me with,
Your Honor, what the state has is the state usually keeps the stock instructions, and it's been the same thing for the last 30 years. They come down with the stock instructions, and the defense either adds or complains about one or two. In this instance, we just believe that specific intent instruction is actually a more correct statement of the law and it needed to be added.
all right, so I'm gonna go pull the case because I'm not familiar with that. And since we do have plenty of time, I have found all the time, because there's a standard, if you will, or whatever, they should be gender neutral in all aspects, and nobody's gone to taken the time to do that in many of these instructions, and I will, as I read them, try to do that. But will you go through all of them? And, well, for instance, here on page, well, they're not numbered, but forgery. So we have instruction at the top and instruction at the bottom. So we're gonna wonder, well, why is this one different than the rest? So there are problems already, and even though they're small, go through each one of them. And do you have the ability to change them? Are they on your?
I can change them electronically, and then maybe I could, I mean, if your clerk isn't mine, I can.
Right,
email them
and, well,
print
you
it.
can send them to my JEA, and she will copy them. But let's see that those changes are done.
And the other thing that comes to mind, Judge, when we have a multitude of charges like we have here, right to count 11, I would ask that we put on the verdict form burglary and some clarification of the charge burglary on the date of forgery on the date of, or as it pertains to false statements or instructions. We've got count 1 burglary with no explanation, 4 burglary with no explanation. We've got no, sorry, Judge. Count 5 or 6 with burglary with no explanation. Since the state's theories of liability are varied, I believe that we would be doing equal and exact justice by including exactly what the date and allegation is. Forgery as to what? 100 statement, forgery as to financial, this is 1 or 2 word explanation. As it is 11 counts and with slightly different theories of liability, I think we're asking the jury to potentially come back with a conflicted or inaccurate verdict on that form.
And, Your Honor, I don't believe that information is appropriate on a verdict form. The jurors will have a copy of the indictment that's contained within the instructions, and that specifies which counts are for which dates and for which conduct. it's not the custom and practice of this jurisdiction to provide much detail in the verdict form beyond the count number and the charge and the option for not guilty and guilty.
No, unfortunately, my colleague is preferred, and normally she's right, but when we got a large multitudinous counts, but we also have two different theories of perjury. And I would think that the document should be a little clearer for the record.
And again, Your Honor, all of that information.
No.
I'll
You have
stop
to
talking.
say, they have the amended, it is an amended one. Oh, no, it is the indictment. And certainly you are free to discuss those. I assume the DA will also explain or do whatever, but the simpler the verdict form, the better. We get into problems when we start, not that you're asking for it, but that would be like basically put the entire indictment, explaining, etc. So I expect you will discuss each of these. I'm sure they will. So I think that's the better way to do it. I only give them as a example, I only give them one verdict form. So they won't have copies. I should have said that. They won't have copies. They will have the original in a blue backer. And the reason for that is, I'm sure you're aware and have seen and read cases where they sign and do one, but that was just a draft and it comes out, it creates, and I tell them this, I only give you one because it creates problems. That if you spill coffee on it, if you do mark it wrong, whatever, that's fine. We will substitute a new one and take out the old one. So there is no miscommunication in that regard. If there can be problems, I hate to say it, and an example of that is names wrong on things. We had that last week. The simpler, the better. Let's start off with the verdict form, as you have provided me. This is the proposed verdict form from the state. That's
Yes,
the
Your
question.
yes, Your Honor, I'm sorry.
And is the state obviously agreeable and accepted that verdict form?
Yes, Your Honor.
Defense, do you agree upon the verdict form?
No, Your Honor, I'm concerned that it's confusing as it is drafted, and I asked for at least a 3 or 4 word explanation, at least to the date of the offense, on each of the counts, so the jury at least knows when they're checking the box what elements they're talking about. As we sit here now, the state has alleged that on 3 different dates he went into the courthouse, and somehow they defined he went there with the intent to commit a crime. Offering false statements, I would think we should at least have reference to what the document is, and then forgery, what specifically, what there is. You're also going to see that Ms. Mishler has pulled out 2 different theories of perjury, and both counts 6 and 8, the same actor, we want to perjure either one way or the other, and I believe we should have some more explanation in this verdict form.
Other than that, are you okay with the verdict form?
Yes, Judge, it's a standard verdict form.
And
Your Honor,
I've already ruled on that.
I know, Your Honor, I just actually noticed a typo that I made,
Okay.
which is kind
That's
of
why, that's why, what I said, nobody's listening. I am gonna go and read this case that you provided me, 'cause I tried to be as informed on whatever case law you give me. While I'm doing that, go through each and every page. And I just pointed out one mistake. So, red line, any other mistake, spelling or otherwise, and then you, meaning both of you, will get together and do a final version and then email it to my JEA. We will print that out and go over that along with, then I will discuss with you Ratzlaff and hopefully finish this up. Okay.